Hello, and welcome to Law 201, Session 8, Free Speech. I'm Robert Corn-Revere, a partner in the law firm of Davis Wright Tremaine LLP in Washington, D.C., and my law practice involves the law of freedom of speech. I'm also an adjunct scholar at the Cato Institute. Free speech is a basic natural right. It enables human flourishing, and it is essential for political freedom, which is why it is one of the first rights authoritarian governments restrict. Yet even in relatively free countries, we see various restrictions on speech, some legitimate, some not. Fortunately, from its birth, the United States has led the way in protecting speech, at least in principle, if not always in practice. The First Amendment to the Constitution reads in part that Congress shall make no law abridging the freedom of speech or of the press or of the right to peaceably assemble and to petition the government for a redress of grievances. It also protects human conscience in the form of freedom of and from religion. Now, although the text of the First Amendment prevents Congress from restricting speech, it has been interpreted by the courts as limiting government at all levels, federal, state, and local, as well as action by the various branches of government. The First Amendment's command seems simple, but it's not. You cannot, for example, hand a bank teller a note that says, "Give me all your money." The terms freedom of speech and abridgment are legal terms of art that have been interpreted by court decisions to give meaning to this constitutional right. And freedom of speech protects more than just words. It protects all forms of expression, including symbolic expression, music, art, and much else. More precisely, the First Amendment establishes a presumption that speech will be protected from government restriction unless it falls into a particular category of expression. Thus, as a matter of historical practice, protection does not extend to such things as incitement to crime, disclosure of national security secrets, true threats, defamation, fraud, extortion, and obscenity or child pornography. However, as the law has developed, the legal definitions for each of those categories have become more exacting. So before government can limit speech, it has the burden to prove that speech falls into one of those limited categories. Moreover, whenever the government seeks to regulate speech based on its content, it must prove that the measure serves a compelling interest and that no less restrictive means are available to serve that interest. Laws that are subject to such strict scrutiny are rarely upheld by the courts, and laws that discriminate based on viewpoint are almost always never upheld, because government must remain neutral toward different political or ideological positions. That is why what is often called hate speech cannot be banned merely because it is offensive. Similarly, under the First Amendment, the government cannot engage in prior restraint or silencing speech in advance except in very carefully limited circumstances. Nor may government restrict expressive enterprises through the use of licensing or other regulatory requirements. Although various communications technologies like broadcasting have been subject to somewhat different levels of First Amendment protection, newer technologies such as the Internet have received the full scope of First Amendment protections. In other nations, including relatively free ones like Canada and the nations of Europe, protections for speech are generally not as robust as in the United States. Thus, Article 10 of the European Convention on Human Rights states that everyone has the right to freedom of expression, including the freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. But that guarantee is subject to certain important and often vague restrictions. Article 17 of the Convention provides, for example, that no state, group, or individual has the right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth herein. And even though Article 10 protects free expression, it also conditions this right on restrictions deemed necessary to preserve other values, including the protection of the reputation and rights of others. That may sound reasonable, but in practice, European law subjects the protection of speech to a multi-factor balancing test. The first step in that test is to decide whether the speech at issue is free expression that is entitled to protection. Under Article 17, certain expression may be excluded from the protections of the Convention, including Article 10, if they are determined to be, for example, hate speech. Under this process of exclusion, the European Court of Human Rights has held that such things as anti-Semitic speech, political advocacy based on racial divisiveness, and Holocaust denial are outside the protection of Article 10. Religious intolerance and blasphemy are also excluded. In summary, free speech is a basic natural right that enables human flourishing and is essential for preserving political freedom, as tyrants have always understood. Second, speech includes a wide range of expressive activities like art and music. Finally, there are certain principled limits on speech that are consistent with a free society, but there must be a heavy burden on government to justify those limits.